G'day there guys, it's your Aussie Hubby Markee, back at it again with another r/legal advice video. Now if you love me as much as I love you, then you know what to do. I want you to run at that old like button and tackle it like Steve Irwin would a crocodile. Maybe even chuck an Aussie flag, a crocodile, or a nice handsome man down in the comments. Now with that said, I want you to sit back, relax, chuck a shrimp onto the barbie, and get ready for some bloody good legal advice. Now our first post today is by DaDude42, titled North Carolina. Sold them a used car, now they sued me over it. Small claims procedure. First of all, apologies for mobile formatting, and had to type this up and ask right after I got the court summons. My wife and I decided to sell her Jeep about a month ago. A local couple noticed it on Let Go, and we sold it to them that weekend. The next Monday, I get a text from the wife, asking if they can return the car to us and get their money back, as it developed a rattle and they believed it is unsafe to drive. Well, that rattle they heard was the same one they heard on the test drive, and the same one that I pointed out to them as being a loose exhaust hanger. But no, this was a new rattle they hadn't heard before, and they wanted their money back. My wife and I declined, and they threatened suing us for it. I laughed it off. They wouldn't do that over something so stupid, right? Wrong. I just got a summons in the mail today. So my question is, do they have a case at all here? Everything I've read online from places like FTC states all private sales are as is, and it is on the buyer to properly examine and educate themselves before the purchase. Am I wrong in thinking that these two are being major PITA, just for the sake of it? Finally, what should I bring to the court with me to get us out of this? Now, it wouldn't appear you've described any sort of case. One guesses they'll say something other than, yeah, we bought a car as is, and now we want to give it back anyway. And the difficulty in predicting what something may be is why you might seek an attorney in handling the matter. It won't be your burden to prove anything in particular about this sale. As you point out, the sale was as is, unless they establish that it was otherwise. You might bring your bill of sale and be prepared to discuss the events as they transpired. You may want to document your interactions with them. Write notes of how the transaction went, stay objective, and avoid sounding judgy or equivalent. The hearing won't be soon. Don't try to rely on your memory. Caveat emptor. You have nothing to fear unless you also offered a warranty. Too easy. I figured as much. You have to show up at court though. Definitely. You'd be amazed at the cases that are lost when people don't show up. 1. You're not wrong in thinking that. 2. Bring copies of all documentation you have about the sale, and any communications between you and them. You and your wife should probably both go. 3. Did they sue you in small claims court in the county you in, or in their county? 4. Go to court. If you don't, then they will probably win by default. In North Carolina, you can hire an attorney to go to small claims court if you want. I don't know that I would bother. And they said that they filed in the same county that we live in. And our last comment is by Derelict. Dress well for court, bring everything you have from the sale of the car, including listing. Bring Blue Book prices, any other ads that show what 17-year-old Jeep is/has sold for in the area. Be courteous to the judge. Direct all comments to the judge, and nobody else. Keep answers concise and to the point. Double down on the, Your Honor, as you can see I never offered or implied a warranty. Your Honor, I sold it to them as is, in the same condition it was when they test drove it. You can always step into a law office and get a 30-minute quick tutorial on what to bring and how to handle it. Shouldn't cost you much. I personally wouldn't hire a lawyer to represent me. The risk here is just too low. Worst case, which won't happen, you get the Jeep back, give them the money back, and you resell it with better documentation. I will be doing this for damn sure. Solid way to play it. I would also just make sure you have mileage and condition locked. Know if it's a fun scam to get the car for the weekend and put a bunch of miles on it, or etc. Seems like a lot of effort just for a joyride, I'll say. And now, update. North Carolina, sold them a used car, now they sued me. Small claims procedure. A lot of stress was lifted from our shoulders today, thankfully. This morning we had our court date, and let me tell you, it was pretty quick. Got in at 8:32, out by 8:50. The plaintiff presented her case. in which she said that we hadn't disclosed an airbag light that was on the dash, and that the check engine light code we told them about was false information because it actually turned out to be another issue. Said the vehicle had more rust than they originally knew about, and that they hadn't driven it because a mechanic told them it was unsafe to drive. We presented our defense, clearly stating that they had the opportunity to have that vehicle checked by a mechanic, but chose to take our word for it, and that we brought all known faults to their attention prior to selling them the vehicle. Anything they found after they took ownership wasn't our issue anymore. They had all chances to make a proper decision prior. We brought up the FTC's private sale guide, stating that all cars sold from a private party to private party are as is, unless otherwise stated. We neither expressed nor implied any warranties. Long story short, the magistrate dismissed the case with prejudice to the plaintiff because North Carolina is a buyer beware state, and the buyer should have done in all their power to make an informed decision before purchasing the vehicle. They have 10 days to appeal, but I doubt that's going to happen. Thanks to everyone that commented and gave my wife and I more information on the original post. It sure helped. Alright, and our next post is titled, "My landlord called the cops on me for trying to pay my rent. Cop made her let me pay, now I'm being evicted for non-payment." This is in Texas. So, there is a very long and convoluted backstory, but in July, my apartment complex was bought out by one of those property flipping companies. They left me without air conditioning for 17 days in heat over 100 degrees. When I complained, she told me to call the city. They shut down the website where we could make payments. This was never an issue when I could pay online, and I was never late in the year and a half before this company bought my complex. They've made my life an absolute living hell and will not allow me to pay, racking up more and more late fees every month. This month I went on the 4th to pay my rent. It was one day after the late fee policy, so I expected to pay a $50 late fee. She told me she could not take my check. My lease says checks are accepted through the 10th. I was already exhausted with her after the air conditioning fiasco and told her I had to pay my rent, and I tried to leave the check with her. She told me she was calling the cops, and I left. I got a knock on my door and thought it would be the cops. It was her. She gave me my check back with a copy of my lease. It said in handwriting on the back that checks are accepted the 1st through 3rd. On the front, in typing, where I signed, it said checks are accepted through the 10th. I went back in there with the check and tried to show her where it says I could pay by check through the 10th. She would not listen to me. She would not even look at the lease I was pointing to. The cop finally came, talked to me, talked to her, then told me that she said she'd make a one-time exception and take my payment. I thought this month's hell was finally over. Today, 4 days later, I hear someone trying to unlock my door. I quickly got dressed and went to the door. It was her with her key, trying to come in. I asked her what she was doing, and she handed me an eviction notice. She said she could not accept my check because I had an NSF before. I have once, because they took so long to cash it and I forgot about it. That was my fault, but this is not. My lease also says no checks will be accepted after 2 NSFs. I have only had 1. My eviction notice says I have until the 11th to get out or they will change the locks. I can't afford a lawyer and I need help. They're in violation of my lease and tried to enter my property without notice or permission. A cop was here and told her to take my check. What do I do? Here's an outline of the eviction process. You're at step 1. They can't lock you out on the 11th. Get all your evidence together and wait for your court date. Make extra copies of your lease and keep one in your car in case they do lock you out. I'm sorry, I'm confused. The paper they gave me states I will be locked out on the 11th. They also wrote on your lease that checks cannot be accepted after 3 days. These people don't seem very honest. Unless you've ignored your court date, it's illegal for them to lock you out prior to an eviction hearing. They are not honest and do not care about the law. This is the second time they've tried to enter unlawfully, and they've towed my neighbor from his paid parking spot 3 times. Have you called the police? Local housing authorities? What advice are you looking for here? I'm newish to Texas and I don't know exactly who to call. Would the police help with a matter like this? This is my first rental from a huge complex, and first rental in Texas ever. If you're illegally evicted, yes, the police can force them to let you back in. The actual landlord-tenant dispute is civil though. I would suggest finding an attorney at this point. You may shortly have a case for illegal eviction. In the meantime, I would suggest you consider putting up a surveillance camera in your apartment in case they come in while you're not home. That way if they steal something or throw out your stuff as part of the illegal eviction, you have a record of what's taken and can report it to the police and/or sue if appropriate. In every lease, there should be a mention of a payment section that describes the legal method in which you can pay, and they're obligated to make a reasonable effort to provide. If they aren't doing that, they're in violation of the lease. AC is also an issue of basic habitability in Texas, and the best thing for you to do is contact the Texas Rental Authority to enforce your rights. They just want to make you leave, but Texas has a lot of tenant rights. Thank you, I will contact them. They are in violation of my lease in so many ways. They have pro bono attorneys just for this kind of thing. Good luck. Can I just say that this is why I love the internet? This person may have just had help with an incredibly difficult time in their life, and it's all thanks to the knowledge of huge purple nipples. Honestly, it's one of my favorite parts too. I love feeling like I can help someone I don't even know with my knowledge of a particular area of the world. Thanks for the kind words. Texas requires one person at the property management company to be licensed by the real estate board. Call the company and find out who their licensed person is, and file a complaint against their license. When you call, you might let them know why you are filing a complaint against their license. They might back down on their threat to evict you. Do that in addition to the other suggestions about safeguarding your valuables and showing up in court if you are served. I wouldn't bother telling them anything. Just get the information you need and go file your complaint. You shouldn't threaten to file in order to make them do anything. No need to get into trouble trying to extort people. Also, there's no need to broadcast your strategy to your opponents. Say as little as you need to get what you want. If OP can avoid having an eviction filing on their record, it will be better for them going forward. It's possible that the licensee doesn't even know what their employees are doing. So while you're correct that there shouldn't not be a threat of anything, I would still call and talk to the person who is going to get to the complaint. I'm not a lawyer. However, do work with property management companies. In addition to preparing and copying the documents for court, try contacting the company that manages the property. If they have a lick of sense, they'll hear about the manager trying to modify the lease and put a stop to this before a judge does. The management company's logo should be at the footer of their website, and you can usually find contact information on the corporate site. Also post on their social media. In competitive markets like Texas, a negative review can cost them a lot of money. Even if you don't get evicted, look for a new place. Companies that flip properties need residents to leave so they can do their work and lease at a higher rent. So they're going to want you gone regardless. Good luck. And now, update. My landlord called the cops on me for trying to pay my rent. Cop made her let me pay. Now I'm being evicted for non-payment. Texas. Thank you for all the wonderful advice. I definitely feel more educated and informed about my rights now. I'm no longer being evicted, and I got all of my late fees back as an account credit, except for $5. But at this point, I don't even care to ask why. I used the property records to hunt down their main office in Houston, I live in Dallas, and forwarded them the same email outlining all the ways they had violated my lease that I had sent to the TAA, the city, as well as apparently pointless, thanks guys, BBB. The guy there got me set up with online payment system that they actually do have, contrary to what their office manager here told me. Next month, I can just pay online. He went through my account, got it paid, and refunded me $125 in late fees as a credit. I actually overpaid $5, but it's mostly a win without having to go to court. I also have the contact information for a pro bono place that specializes in housing, just in case I ever need it. Thank you all so much for the overwhelming amount of responses and information. And our next post is by user NJThrowaway2019, titled Neighbor Touched My Son, New Jersey. Throwaway just because. First, let me say, I'm a longtime fan of this sub and really appreciate the help y'all provide. Location, New Jersey. Now, there is a deaf and mute man in my neighborhood, henceforth neighbor. Neighbor lives maybe a half a block away from us. I assume he also has some other special needs as he doesn't drive. He rides a bike all over town and has clearly no job. He's around the neighborhood all the time. Neighbor has always come around when we've been out in the yard and played with our children. Son 5, daughter 3. My in-laws have always been creeped out by him, but I try to be open-minded and reserve judgment. I'm currently enrolled in grad school and had class this evening. When I left, the kids were in the backyard playing with neighbor while my wife was doing some gardening nearby. About an hour into class, I received a text from my wife. We are done with neighbor. Son just requested to come inside because neighbor kept touching his private part and rubbing his belly. Needless to say, I'm livid and questioning my faith in humanity. We will be taking a trip to the police station tomorrow morning to file a report and possibly request a restraining order. I am not under the delusion that any form of prosecution will occur, but we know the police will need to be notified. My questions. 1. Is there anything I should prepare before we visit the station? 2. Would a restraining order be the right thing to pursue? We don't need hundreds of feet of clearance. I just don't want the guy on my property to attempting to contact anyone in our family ever again. 3. Is there anything else I should be doing? 1. Don't prepare, particularly where your son is concerned. They'll want to question him without any direct coaching or indirect influence from you. All you should tell him is the police are there to help and he should tell the truth when they ask him questions. 2. A restraining order will probably be easy to get in these circumstances. The police can help you with that. Normally I'd say tell the guy first that he's not welcome anymore and call the police if he shows up again after that. But even if he doesn't understand what he did to your son, it's inexcusable and the nuclear option is justified. 3. Counseling for your son. He may not be traumatized at all, but it would be to his benefit to be professionally evaluated and guided through coping now, rather than waiting years to see if something manifests. Just to be clear, preparing my son was never an option. I want the truth just as much as anyone else, and will take special care not to ask leading questions or the like. The question was more along the lines of, do I need to be prepared for CPS to question my family? Or other things? It would be our preference that this is a simple visit to the station to file a report, and possibly a restraining order. I guess what I'm asking is, should I be prepared for it to be more than that? And if so, what should I expect? Regarding counseling, I think an evaluation is a great idea. We're doing our best not to turn this into a bigger deal for my son than it already is. Portraying our trip to the station as, hey kids, let's see what a police station looks like and to maybe get a tour, and the like. But certainly an evaluation by a pro is a good idea. Thank you. Police are mandated reporters when they know of abuse, but I would be surprised if CPS has to be involved in this case. The abuser is known, isn't family, and you're reporting it promptly. There's not going to be any indication that your son is in imminent danger. That said, if they have to report it regardless, the investigator will likely talk to you all briefly, see a clean home with toys and food in the fridge, and write it off as a formality. And now, update to that post. I know the original post didn't get a lot of attention, so there probably isn't much demand for an update. But I did want to thank the people who commented and maybe give some guidance on expectations for anybody who might have the horrible luck to fall into a similar situation. Also, it's just not something we want to talk about with friends and family, so call it therapy for me. Update. On Tuesday morning, the entire family went to the police station to file a report. My wife and I interviewed with an officer and detective together, at first, and then my wife alone. After that, the detective contacted the county prosecutor's office. An hour or so later, we're on our way at a county facility, so we could all be interviewed by a couple detectives from the county prosecutor's office. Once interviews were over, the county detectives sat down with my wife and I to let us know my son had given them some actionable information and they intended to act relatively quickly. The detectives who interviewed the children had tears in her eyes. From there we went home. That afternoon, neighbor knocked on the door, looking to play with the kids. I opened the inner door, left the storm door closed, and made it clear he needed to go away, which he did. Soon after, I went to night school, asking my wife to stay indoors with the kids for the night, which she did. When I got home, she said nothing else had occurred. For the most part, Wednesday was quiet and relatively normal. We did not see the neighbor all day, and Wednesday night we came to know why. A detective called us to let us know neighbor had been taken into custody on Tuesday night while I was at school and would remain in custody for a few days until his hearing. I assume arraignment. Thursday morning, a woman from the state DCF/CPNP office came to the house. She made a cursory check of the house and interviewed my wife and I together. To my mind, this was actually a good thing. She was able to let us know that neighbor had been charged with 2 counts. I don't recall exactly what they were. She also provided other important facts. 1, the neighbor had a history, albeit old, late 80s, early 90s, and in California. 2, neighbor had admitted to the act to the detective that arrested him on Tuesday evening. From there, she advised we were entitled to have my son evaluated by a state specialist and possible therapy if necessary. We will need to have them check in with us once a month until the case is closed on their end, and the evaluation, etc. will necessarily extend that time frame, but we opted to go this route anyway. While she was there, I asked if she knew what the likely penalty was, which she did not, and whether or not she thought we should pursue a restraining order, if the neighbor was likely to be free again soon. She was unsure and promised to check in with the detectives on the subject. Friday, yesterday afternoon, we received a call from the county detective. She informed us that the neighbor's hearing was set for Monday and that his lawyer intended to ask that he be released to his home, with an ankle monitor for the period between the hearing and his trial. She wanted to ask for our input as to how hard the prosecutor should push to have the neighbor remain in custody. Here's the thing. Neighbor, so far as we can tell, actually lives with a family and they have small children. I advised the detective that we're okay with the neighbor being home, so long as he was confided to approximately his property. She confirmed that would be the case, and that a no-contact order would be in place. We agreed that that was okay with us, but also said we felt strongly the family with whom the neighbor lives should have input. That brings us up to date, and to be honest, I am torn. I hate what this man did. I hate that it has happened before, and I never want it to happen again. With that said, at first I was unsure as to whether the neighbors even knew what he did. He clearly has some emotional and intellectual challenges, but he also knew, at least to some extent, what he was doing, as he admitted the act to the arresting detective. I get the feeling he is something akin to a deaf and mute Lenny from Of Mice and Men, and that tears my heart out. I don't think he really understands, and I don't want to be vindictive to someone like that. At the same time, he touched my son. If there were no clear impairment, I would want to take a baseball bat to his head. But there is, and instead I feel like crap for everyone involved. This sucks, full stop. On a more selfish note, the Megan's Law Registry. There are a handful of homes for sale in the area. Until now, my wife and I were hopeful that more families with children would move into the area. That hope is now over. Because neighbor's history all predates Mega's law, he was not on the registry and now he will be, and no families with kids will move into the area. I realize this is tangential to the main topic and pretty self-centered, but it's just one more way that the neighbor is going to make our lives a smidge worse, just by existing. To repeat myself, this sucks, full stop. Sorry for the book, and if the mods see fit to remove the update, as it's not all that particular to legal matters, I understand. Honestly, I just feel a bit better getting it all down and putting it out there. Thanks to anyone who reads through. Alright, and that's all for today's r/legal advice episode, guys. I hope you enjoyed this one. Tell me what you thought of it all down in the comments below. I'd love to see your commentary, what you think of it, and what you didn't like about it, I guess. This has been Markee. Hope you're enjoying your quarantine today. Let's keep spirits high, guys. And I hope you have a good day, night, sleep, whatever you're up to. I'll see you in the next episode. Bye.